request Mr. Samir to take the session forward and enlighten us all. You can all ask your questions in the chat box.
Thank you, Garima, for that kind introduction. A very good afternoon and probably good evening or good morning from wherever you are joining in. I can see a couple of international guests also here. Today's topic, which has been given to me for speaking about, is mandatory or compulsory mediation. Now, this topic itself seems a little contradictory in the sense that we all have been taught that mediation, or for that matter, the ADR, any ADR process, is voluntary in nature. That's one of the basic aspects of an ADR. And so therefore, this particular topic seems little contradictory and controversial for that purpose. But I personally don't think so, that it is that contradictory, because a stage has come now that to a certain extent, it is beneficial for the parties as well as for the society in general to at least make mediation, and for that matter, other ADR process like conciliation, a mandatory process before the parties go to the court, which is an adjudicatory process. Now, coming to the brief history about mediation, I mean, it is nothing new. Mediation in its unstructured form, or I would say an informal process, was already there since time immemorial. If you go back to the history, you will find mediation has been part of the society's culture, or as a process of implementation of law and order within the community as such. So what was happening initially, and it is in fact prevalent even now in our day-to-day lives, we do mediate, maybe not consciously or in a structured way, but in everyday life, in different relations, be it friends, family, even professionals. We do indirect mediation, for that matter, in cases of dispute or conflicts. So therefore, mediation as such has been there with us, and it since ages. What happened is that a need was later on felt to put it in a structured form, because it definitely has immense benefit. Because ultimately, why mediation is beneficial? Let us first understand, and then we'll go to the compulsory part. Why mediation is beneficial? Because ultimately, if you see, all the conflicts, for that matter, is between two human beings, two or more, for that matter. Let's take a simple example of two persons who are humans. And we are talking, when we are talking of humans, we are talking of here the emotions, basically. Emotions can be in very different, varied ways. Yeah. And therefore, when we talk of emotion, in many cases, an adjudicatory process may not be good, may not be beneficial for the parties. Yeah. And therefore, we say that mediation gives you a win-win situation. Because in mediation, it is, let's say, a person who's aggrieved, knowing that he or she is on a weaker footing, can still, through mediation, through effective negotiation, and I'll come back to this word effective negotiation, can able to achieve benefits in his or her favor which he or she may not have been able to achieve in a court of law. Similarly, from the opponent side, same consideration is also applicable. Therefore, we say that mediation always gives the parties a win-win situation because it is the perfect example of party autonomy. It is the parties who themselves make tailor-made solutions or resolutions to their dispute in mediation. Of course, through the able facilitation, guidance, and help of the mediator, no doubt about that. But ultimately, mediation has that immense effect of diffusing even a grave situation between the parties. And therefore, you need what felt to, we have seen now theories and, different types, different nature, different methods and modes of mediation coming into play. And all, of course, depends upon person to person who's mediating, or depending upon to case, what kind of case it is. Yeah. So therefore now, so we have seen, theories being developed, different processes within mediation being now developed to tackle different situations. There are certain definite processes which are always helpful, which should be employed by a mediator to help parties to ensure a settlement, effective, mutually acceptable settlement between the parties. Now, having said that, what is the need? Do we still find that in spite of such open and flexible mode, why we are talking today of a compulsory mediation? What is happening in mediation? Why we need a mandate for parties to mediate? Now, the reason is the basic nature of mediation, which I said is voluntary. You see, many times, and if you research the data, it has seen that because of the voluntariness of the process, the parties and especially the opponent does not appreciate or does not consider this mediation process as an effective process to participate in it. And therefore, what is happening that ultimately a mediation from the very beginning becomes a non-starter, unsuccessful. And therefore, it is highly required now to make mediation mandatory, compulsory, at least in certain cases, like, for example, family disputes. Now, in family dispute, again, majority of these disputes, or I would say almost all such disputes, happens because of the emotions, because of the ego clashes, because of the cultural differences. So ultimately, it all revolves. There's no law being disputed amongst the parties between husband and wife, or between brother-in-law, father-in-law, son-in-law, sister-in-law. There is no law being discussed or disputed between the parties. They are talking about their personal issues, where law in its current framework may not be effective. I'm not saying law is not effective. I'm saying it may not be effective, in the sense that, as we all know that law does not recognize emotions. Yeah. So therefore, that is the limitation of law, the process of law as such. Therefore, in such family disputes, for that matter, in my personal view, it is mediation which should be made mandatory. Now, how do we make it mandatory? There are two ways of doing it. One is by under the contract. where the parties themselves decide that before they refer their dispute to an adjudicatory process like arbitration or litigation, they would first approach the process of mediation to resolve the dispute. This can be under a contract. Okay. And the second way in Elma, can you just ask person to just mute?
Yes, sir. I did message them also.
Doesn't matter. I think it's done now. Okay. So sorry about that. Anyway, so the second way of making mediation mandatory compulsory is of course through the legislative process. Now, when we talk of legislative process, let me just give you a brief picture of what is happening or what has happened in our country, in India, so far as the legislative part is concerned to make mediation compulsory. It started way back in 2002 when Section 89 was incorporated in the Code of Civil Procedure, which made it on the court to refer such dispute which the court thinks may have the degree of or possibility of settlement to the ADR processes like conciliation, arbitration, judicial settlement, or mediation. Now, again, there is a openness so far as the mandate is concerned, and therefore this particular section and its constitutionality was made subject matter of a very landmark case, which is known as the Salem Advocate Bar Association case, the first of one such case, because there were two such cases which happened in our country. So the first, and both are landmark cases so far as Section 89 and mediation is concerned. So therefore, the first case it held that Section 89 is constitutionally valid, yeah, and therefore it established a committee to draft rules on mediation for the benefit of the courts and the litigants in general. Now, this committee actually published a very detailed report, and I think if you are interested in understanding this concept of compulsory mediation and the development of mediation, especially in our country, in India, please read this judgment. It's a beautiful judgment where court have gone in very much detail. The Supreme Court of India has gotten so much detail about this, the aim and purpose behind Section 89 of the Code of Civil Procedure. So this committee, which was established, it published a detailed report which contained the guidelines to the courts on manner of referring cases to mediation. Okay. It also, so these rules which came into published, which was drafted by this committee, were known as the Civil Procedure Alternative Dispute Resolution Rules. Now, around the same time, there was another bench of the Honorable Supreme Court of India, which was dealing with a similar issue between the same litigants, and which is known as the Salem 2 case. Yeah. And here, this particular bench, it directed the high courts and the central government and the state government to file a progress report with respect to adoption of the rules which were drafted by the first committee in the Salem 1 case within 4 months of date of judgment. So this happened in 2005, I suppose. Yeah, in 2005. And in between, a very important step was taken by the then Chief Justice of India, Honorable Justice R.C. Lahoti, who established the Mediation and Conciliation Project Committee, shortly known as MCPC. And the purpose of this committee was to establish court-annexed mediation centers in several states and ensure that the mediation rules to be adopted in various court-annexed mediation centers were uniform, that training was imparted to the mediators, and so that there is a consistency in their approach, and that mediation is implemented at the national level. So this is another very important aspect which led the court as such to take support of mediation for effective adjudication of the disputes. And in fact, we have seen that there are several such court-annexed mediation centers being set up. In fact, the first one to start under this project happened to be in Ahmedabad. It started in Ahmedabad City Civil Court, and now you see it as being effectively being, being run at, especially in court in New Delhi, in Bangalore, in Mumbai, and many other states. Another important landmark judgment, again supporting mediation and its effectiveness and to make it as a sort of mandate in our country, which happened in 2010. Again, a Supreme Court judgment known as AFCON infrastructure judgment, where the court actually was dealing again with the ambiguities of Section 89 of CPC, and it attempted to provide the procedure to be followed by the court while referring cases to ADR forum under Section 89. So this is again a very important landmark judgment, which if you are interested, you must read to know how the Supreme Court of India has again laid down the process of how the different courts in states should employ the beneficial process of Section 89 of CPC for referring the matters at a particular appropriate stage to mediation or different ADR processes. So these were the first initial steps in our country recently, which helped the progress towards making mediation at least part of the mainstream adjudicative process as well. Though mediation is definitely not adjudicative because it is not, binding in the sense that it's not necessary that the parties will come to a settlement, but at least they will try to sit together, work out and narrow down their issues of the dispute. That's also equally important. They may not achieve a settlement in mediation, but at least through the negotiation, through the help and guidance of a wise and experienced mediator, the parties would definitely try to narrow down their issues, different issues in their dispute. So that will also be helpful for the court if the matter, because it is not settled, definitely will go back to the court to then, just dealt with only those unresolved issues. So this will also help to, reduce the time spent in the court for the adjudication of a particular case. We all know how big the backlog is today in our country. And of course, the recent COVID situation had added to that backlog. Yeah. Recent report I was reading, I think it says that there are almost 4 crores of cases which are now pending before various courts. Now, this is mind-boggling. Then we definitely we can say that many times people have lost faith in the court system, and to an extent rightly so, with all due respect, I would say. But the reason is this, that in spite of these guidance, in spite of these landmark judgments, unfortunately, we have still not been able to take the best advantage of the process of mediation for the effective adjudication of disputes. There's still a more, impetus to be given both by the court as well as by the bar. So both bar and the bench have to work together to have this, to take this best advantage of effective mediation for the adjudication of process. Now, going further, these were the initial, steps taken by the court as well as by the legislation to make mediation, to put mediation into the mainstream. Later on, another very important legislative change which came in 2018 in the Commercial Courts Act. And in 2018, this is, I think, one of the most important legislative landmarks to make mediation at least compulsory as a mandate in our country. And the particular provision of this act is Section 12A, which now also known as the Pre-Institution Mediation Rules. So what this 12A, which was inserted in 2018 in the Commercial Courts Act of our country, it says that the first section itself puts mediation as a mandate. And if I just read it, it says that a suit which does not contemplate any urgent interim relief shall not be instituted. These are very important mandatory words. Shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by the rules. Now, understand the impact behind these words, shall not be instituted unless. So this is a mandate now, so far as the commercial suits are concerned in our country, that no such suit would be instituted in the court unless the parties have gone through mediation. Now, then there are also mediation, the pre-litigation mediation rules being prescribed, and it lays down the process. Now, unfortunately, what has happened that while laying down these rules, again, the process have made mediation as voluntary to an extent, in the sense that what the rule says that once this application is being made by the plaintiff, the institution or the court annexed institution as such, or the authorized institution, will send a notice to the other side of giving his or her consent for mediation. Now, this is where the problem lies. This is what it has in fact diluted that mandate of Section 12A in the rules. Now, of course, the other side will never agree. Why? Very simple. It's a simple logic. The other side will never agree to come to mediation. And then the rule says then it will be a non-starter. The institute will report to the court, and then the matter would again land up in the court. Then what is the purpose? 12A is definitely a beautiful provision so far as the mandatory mediation is concerned, but the rules are actually diluting it. So I think we need to amend these rules to make it in consonance with the purpose behind Section 12A, to ensure that mediation becomes a mandate, a compulsory process before a commercial suit is instituted in the court. In spite of the fact that there is an exception that in case of, interim reliefs, I would say that let the interim relief be adjudicated by the court, no problem. There's no issue in that. But after the interim reliefs have been adjudicated, let the parties again go back, should be directed to go into mediation, because at that is the stage where there is a effective, there's initial adjudication by the court so far as the interim relief are concerned. So the parties' positions may have changed because of that, and therefore they will be more inclined, to participate, to go into mediation and try to work out a favorable situation respectively. So I think that is where, so in spite of this exception or a sort of exception to in this rule of mandatory mediation, I think what needs to be again amended is that even after the interim relief have been given by the court, the parties must be directed to mediation. Now, this section also lays down the time frame within which the mediation has to happen. Now, this is again an issue of debate, because it lays down time frame of 3 months, which can be further extended by 2 more months, so 5 months as such. But it may happen that because you see, mediation, as we all know, it's so flexible, and it may happen that parties may have reached some kind of stages of settlement, but during this period, this particular mandatory period of 5 months expires, and therefore in such situation, especially the opponent would get a ground or an excuse to move out of mediation. So therefore, again, I think little bit more time must be given in mediation, because ultimately we are dealing here with back and forth negotiation. And here, I would just like to come back to what I mentioned earlier as constructive communication. Now, what happens normally, any dispute or conflict for that matter, generally happens either because of lack of communication or because of excess communication. Both are bad. But what happens in mediation is that this lack of communication or effective communication is balanced through the help and guidance of the mediator into an effective communication, so as to make the parties come to a settlement. So this is very important, and this can happen only in mediation, because in court also there is a limitation on the parties to effectively communicate their case to the judge or to the other side for that matter. Because again, the issue comes of law. We are talking of law more in court rather than the basic rights or the emotions of the parties for that matter. So therefore, effective communication can happen only in mediation, and that is the key for a mutually acceptable win-win situation for the parties. So I think this is where, of course, the amendment to, this particular section 12A in the Commercial Code Act definitely is again a very progressive step of legislative amendment towards making mediation as a mandate, as an important mandate for resolving the dispute. Another important legislative change which came in our country to make again mediation as a mandate is sort of mandate, I would say, not a direct mandate, but yes, the purpose behind it, of course, is to make mediation compulsory. Was made in the year 2020 in the Consumer Protection Act, where a new chapter 5 has been inserted, whereby mediation and conciliation panels have been set up within respective consumer forums and commissions in states, and of course at the national level, and to see that the matters are referred to an expert or the mediator who are empaneled for effective resolution. Because even in consumer matters also, to a larger extent, of course, considering the purpose and aim behind this act itself, which the name itself, is gives us the meaning, or the aim is to protect the rights of the consumers. So it is more beneficial for the consumers to, so that they have provided with such help and support of expert mediators to resolve the dispute. So this is again a very important and welcome amendment in our legislative amendment in our country. Likewise, it has also been now, you see, made a part so far as mediation is concerned in Companies Act, and also in the Real Estate Regulation and Development Act 2016. So likewise, you see, there is a progression definitely in our country to make mediation compulsory, and rightly so. As I said, in disputes like family, partnership, business disputes, they are more on the emotional outbursts, egos, rather than law. And therefore, it is more important that such cases should be referred to mediation as a mandate. Now, let me give you an example of the COVID situation, where I was referred both by the landlords as well as by tenants in different matters to, you see, resolve their dispute, to give them advice what to do. Now, if we look from landlord and tenant, to an extent, both of them were right. The tenants were right in the sense that they definitely were not able to enjoy the property for which they have been paying the rent. They were not able to use the property. At the same time, the landlords were equally right that it is not they themselves or voluntarily they have stopped the tenants from not using the property. Yeah. So issue of force majeure, for that matter, was debated from both the sides. But if this matter would have landed in court of law, then definitely there would be a decision in which either of the parties would be a loser or a winner. Correct? But when these matters were mediated, we came out in majority of the cases with a win-win situation, in the sense that both the parties let go their respective positions to an extent and worked out a mutually acceptable solution. Yeah. So this is where I say that mediation in such cases must be made compulsory. This is need of the hour, definitely. And if I talk of certain international jurisdictions as well, countries like Greece, Turkey, Romania, Italy, and many states in US have adopted this mandate of compulsory mediation in many cases, in majority of the cases. In fact, there's a very, very interesting report which is being made to the Civil Justice Council in UK on this very aspect of compulsory ADR. Please read that report. It's very, very interesting, and it actually deals with two aspects of compulsory ADR and especially mediation. One is about legality, and second is about desirability. So please read. Please, it's a very lengthy report where they have cited certain very landmark cases which happened in England, which initially did not came in favor of having a mandatory mediation, but later on there were certain other judgments of the Supreme Court and the Court of Appeals in UK, which which changed the view and came to conclusion that yes, there is no issue so far as the legality is concerned in making mediation as a compulsory mandate, yeah, for resolving the dispute. So please, again, if you are interested, please read that report. It's a detailed but very, very interesting report, which will help you understand this concept of why we are talking of compulsory mediation. Though in case of England, Abhilasha, I am talking of a report of compulsory ADR, which is made to the Civil Justice Council in UK. All right. So please read this report, because as I said, it will make you understand the reason behind why we are talking of ADR. Though as I was mentioning, though we were in that particular issue was raised in case of UK because of one particular section of the EU Convention on Human Rights, especially at that particular Article 6. But even if we just ignore that particular article, the observation which is made, the recommendations which is made, the conclusion which is made in that report is very, very important to understand why mediation must be made compulsory in majority of the cases. Now today, in fact, in many cases, even which have certain criminal aspect, I am not talking of the bodily harm when I talk of criminality. I am talking of the economic harm as such, so far as the criminal offense is concerned. There also, I think, mediation can be really effective for resolving the dispute. A simple example of check bouncing cases under the Negotiable Instruments Act. Now, I'm talking more from the perspective of India for those international guests here. Now, in case of check bouncing cases, what is actually happening is, apart from the technical issue, which is very, very rare in very few cases, majority of the cases, it is certain, it is very clear that the person who has drawn the check had the liability to pay that amount. Yeah. Now, what ultimately happens? Majority of such cases, of course, they are filed in the court, but they ultimately end up in settlement. Then why waste the time of the court for this? If the parties are anyway going to settle it out, why not at the inception itself, mediation be prescribed to the parties to work out a proper win-win solution, and let that settlement be then authenticated by the court? There's nothing wrong in it. That way, so much time as well as cost will be saved. So likewise, even in such economic criminal offenses, I think mediation must be employed as a mandate before employing the adjudicative process. Now, we have seen the positive aspect of it. But of course, everything has its pros and cons, mediation including. Now, if we are talking of mediation, and that too compulsory, what are the drawbacks? Drawbacks, so far as, if I can take, for example, from our country especially, in spite of, as I said, this whole process runs on party autonomy. And to a larger extent on the basis of the awareness and appreciation of the process by the concerned parties. Now, if that is not happening, then even if you make mediation compulsory, it will not be effective, because the parties must be trained with, must be given that kind of awareness of the effectiveness of mediation. So what will happen that even in case of a compulsory mandatory mediation, let's say, especially the opponent party would just come there, participate for sake of participating, and because there is no surety or there is no process of a binding settlement happening, the time would be wasted. So I think, apart from making it mandatory, there are further few other steps which must be taken either legislatively or otherwise, by the parties to ensure that there is an effective mediation is happening between the parties, even in a mandatory mediation. Now, what could be those steps, the further steps, additional steps? That could be penalties, costs being imposed upon a party who refuse to appear or participate in mediation. So this is just my personal thought process. How far it is good or bad, I don't know. But I think it's a basic human mentality that in many circumstances, without mandate, without strictures, we don't perform as required. So I think these kind of strictures within the framework of mediation must also be prescribed to make the parties understand and appreciate this process, because time has come that the conflicts are going to increase. We are witnessing a very major conflict happening between Russia and Ukraine, and of course its consequences, which will be dire, I would say. What the other nations are doing by imposing those sanctions, it will be a mess. I mean, a very, very dire situation now being unfolding because of this crisis. So conflicts are going to be increasing. But if we do not, mandate certain processes, then it's not going to work. Now, again, taking example of Russia-Ukraine crisis, you see what is happening now. In spite of the case being referred to ICJ, being represented by Ukraine, Russia has refused to come. Yeah. Now what do you do? In spite of the court process, Russia has refused to join it, participate in it, and therefore the sanctions. So this is what I was talking about, that in spite of making mediation compulsory, still it may not be effective unless there are such strictures, sanctions being imposed on the parties to effectively participate and make use of mediation for their own benefits. Because it has happened that, you see, many times very high stake matters, or maybe high conflict matters, have been resolved because of mediation only, because the adjudicative process have failed. So, and this can happen only with the trained and experienced mediators. So this is also a very important part, that training has to be imparted to the mediators, or to the person who's being given this task to mediate, to give that guidance, the required facilitation to the parties for an effective solution to their dispute. So therefore, I would suggest that need or the hour is definitely compulsory mediation, at least in majority of cases, what I just mentioned, be it commercial cases or family disputes or business issues, and to reduce the burden of the court, to maintain the relation between the parties, which is the most important part, that even in spite of your disagreement, in spite of your conflict and dispute, you are still able to maintain your relationships. That is more important, and that can only be achieved through mediation. Now, a simple example of a check bouncing is why the parties, in many cases, they have long-term business relations. Why the parties would like to spoil that relation? They have further business to do. Just because of one check bounce, why the party should spoil that long-term relations? And of course, the future relations. I mean, think from a business perspective. It doesn't make sense. So therefore, I think in such cases, even though it has been prescribed under as a criminal offense, and there is a reason behind that, definitely. But I'm saying that even here, mediation must be prescribed as a mandatory process for an effective resolution. Therefore, to conclude, I would say two things. One is that in court of law, one gets law because it says court of law. So you get law in court. But in mediation, you get justice. Therefore, let's mediate and don't litigate. Thank you so much.
Thank you so much, sir. We have some questions in the chat box. Can we be forced to mediate? Go to mediation? Hello? Sir, am I audible?
Yeah, thank you. I was not able to unmute myself. Can you just repeat the question, please?
Can we be forced to go to mediation?
I mean, that's exactly what I was telling throughout my today's speech, presentation, that in many cases, it is always an effective step to force the parties to mediate. Of course, it all depends upon party to parties, but if the parties are not forced, then ultimately, as I said, many times the adjudicative process will not be beneficial for the parties as such. So therefore, some kind of force or compulsion is definitely required to ensure that an effective resolution is being achieved by the parties in a dispute.
We have
I hope
another
that,
question.
that
Yes, sir.
satisfies the questions. Yeah.
Since mediation is not mandatory in nature, many a time in order to side away the court's proceedings, parties choose mediation as a dispute settlement process and ultimately go to court after mediation, after not accepting the mediation conclusion. Is that vitiating the sole purpose of ADR in India? Your views on it?
To an extent, yes, I would agree with that. And and that's the reason why I mentioned particularly the Commercial Court Act, especially Section 12A, and the rules. You see, which actually has diluted the rules. Actually, have diluted the whole purpose of Section 12A. So what is happening now is that once the opposite party receives a notice, they would never reply to it. Majority of time, they would never reply to it. So it's a non-starter. And going further, even if they agree to participate in mediation, they would just do it for sake of doing it. And that is so ultimately, and therefore I agree with what you are saying, and that is the reason why I suggested that this particular mandate has to be supplemented with certain further strictures on the parties who do not mediate or who do not participate in mediation, yeah, or refuse to participate in mediation.
Okay, sir. In case of consumer and business dispute, who would you force to participate? Both parties?
Of course, mediation cannot happen unilaterally.
Yeah. Can we have mediation as in legislation in this country, or we have special statute on books because where there is no given clause, especially seen in cases filed by financial institutions?
Yeah, so you see, we will now be having, of course, a law in our country on mediation, very, very, in near future, probably in this year itself. So the hopes are that once that law of mediation is in place, I think many of these issues which we are facing now would be resolved to a larger extent. And coming to the question of, since there is no law, how do we go for mediation? I think, as I was mentioning, there are these legislations like the Commercial Courts Act, the Consumer Protection Act, the RERA is there, Industrial Dispute is there, Companies Act is there. So these are the laws which already prescribe mediation, or for that matter, ADR, or effective dispute resolution of respective disputes under those acts. So one must take advantage. Unfortunately, what is happening is that either the litigants themselves are not aware about it. Many times, with all due respect and without any, other meaning as otherwise, the bar members are also not aware, or even if they are aware, they are unable to understand and appreciate the effectiveness of these provisions. Yeah, most of the time, be it the bar or the litigants, mediation is being viewed as a process of compromise, which is totally wrong. It is not compromising. It is getting your due in a fair way. That's what mediation is all about. And if you are, letting something go, but at the same time, you are also gaining much more in mediation, and that can happen only in mediation. So there is not a compromise. So I think this wrong impression of mediation must be taken out of the mindset of both the litigants as well as the bar.
Is report of mediation process required in court as evidence of having utilizing one of the ADR modes?
Of course, the person or the institution who the court will be referring mediation, they will be reporting to the court, but it will not be used as evidence because mediation definitely is a confidential process. So what has been discussed during mediation is not to be reported to the court. So what report would be made is only whether it is successful or unsuccessful. So nothing more will be reported and should not be reported as such. So there is no question of using it as an evidence.
I think these are all the questions we have from the participants. I'll just see if there are any questions left out.
There were certain other questions, I suppose.
Yes, so you can, we have another new question.
Yeah.
If you force parties to mediate, will it not be congested mediation process? So it will be a shifting from a congested court to a congested mediation. Also, you go to court because you want to go and the courts are still congested.
Not really, because not all matters can be or should be mediated. So as I told you, at least we can take a startup with family disputes, business or commercial disputes, and see what happens. Now, unfortunately, in spite of these provisions which I mentioned, it is still not being utilized to its potential. So definitely, I agree partially to your view that all cases cannot or should not be mediated. But why don't we at least give it a start? There's no harm in it. So don't worry. ultimately the court are going to be there. Yeah, the adjudicative process is not going to be abolished, because ultimately the people's rights have to be adjudicated at some point of time. Yeah, at one particular stage. So don't worry about that. So courts, what we are trying to do today is to reduce the burden on the court. That's the purpose. And that's not going to increase the burden on mediation. Definitely not.
Yes, sir. We have one last question. Can the mediation agreement made after mediation process be challenged in the court of law after the particular time? Since mediation agreement is the conclusion of the party autonomy, and if yes, was it the limitation period?
Well, it's a very debatable issue as of now, and as such, it is not related to today's topic, but let me just answer it briefly. In my view, you see, the whole issue of enforcement of a mediated settlement agreement itself is wrong. It's totally contradictory, and it's totally contradictory in the sense that if we are saying that it's a mediated settlement agreement, which means both the parties have agreed in their respective way to a particular solution, then there should not be an issue of enforcement. The enforcement issue comes into play only when one party backs out or is not fulfilling or abiding by the agreement, what is being decided between the parties. Yeah, then only the enforcement part would come into play. But if we say enforcement of a mediated settlement agreement, then I would say that the whole mediation process is unsuccessful. So I think, let me just stop here, at least for this particular question, because otherwise it can go into another webinar.
Yeah, yes, that is a lengthy topic.
But I would say that this can be another topic for the next webinar. It's a very interesting topic. So if you are interested, definitely I would be more than happy to speak on it.
Yes, sure.
So
Sir,
I
we
must
can
thank
definitely do it.
the person who has raised this question to give you and me the next topic of webinar.
Yes. So these are all the questions for now. Thank you so much, sir, for such a vibrant, interactive, and knowledgeable session. I'm sure we got to learn some amazing things today. I would like to thank all the participants for joining us. Before concluding today's session, I would like to take the opportunity to introduce second virtual international mediation competition organized by MediateGuru. You can go to our website www.mediateguru.com. I would like everyone to fill up the feedback form before you leave in order to receive your certificates. If you don't want to miss any updates from MediateGuru, follow us on our social media platforms and join our WhatsApp update groups. Thank you everyone for joining. Thank you so much, sir.
And I would request to at least share the feedback for my personal, improvement.
Yeah, sure, sir. I'll send it to you.
Thank you so much. And thank you all of you for patiently listening and participating in this webinar. Thank you so much. Have a good day ahead.
Thank you.